Thank you, Mr. Chief Justice, and may it please the Court. Over 50 years ago in Bruton v. United States, this Court held that the admission of a non-testifying defendant's confession that accuses another defendant in a joint trial violates the Confrontation Clause, even in the face of a limiting instruction, in light of the uniquely prejudicial effect that such a confession has on the jury. This Court has made clear that the Bruton rule applies to a confession that has been redacted to avoid naming another defendant, where the jury is likely to infer that the confession implicated that defendant. The question presented today is whether the manner in which the redaction is carried out is dispositive of the application of the Bruton rule. The Court should hold that it is not. In this case, the prosecution substituted phrases like the other person for petitioner's name. But having done that, the prosecution used the confession functionally to identify petitioner. The prosecution's questioning of the agent who took the confession left little doubt that the confessing defendant had named the other person. Petitioner was the only defendant who plausibly could have been the other person. The prosecution described the confession as some of the most crucial testimony in the case. And having elicited detailed testimony that the other person had met up and lived with the confessing defendant, the prosecution proceeded to present evidence that petitioner had done just that. In light of those considerations, it is likely, indeed inevitable, that the jury inferred that the confession here implicated petitioner. In applying the Bruton rule, lower courts have considered the broader context without any evident difficulty, and doing so appropriately protects a defendant's confrontation right while working minimal prejudice to the government. The government's alternative approach would draw arbitrary and formalistic distinctions and permit ready circumvention of the Bruton rule, as this case illustrates. If Bruton is to mean anything, petitioner is entitled to a new trial without the introduction of the unconfronted confession. I welcome the Court's questions.
You said that the testimony, the redacted testimony, functionally identified petitioner, and that the jury inferred that it would be the petitioner. How is the inference and the functional identification testimonial here for Confrontation Clause considerations?
So I think we are all in agreement that the Confrontation Clause applies here such that if we were in an individual trial, Crawford would apply. And I would point in particular to this Court's decision in Melendez-Diaz, which made clear that for evidence to be testimonial, it need not be on its face directly accusatory against the defendant. This Court indicated that evidence that is hostile to a defendant's interests can qualify as evidence that is against the defendant.
So I don't want to, excuse me for interrupting you. Let's take a step back. Tell me exactly what is said in the testimony that directly speaks of the petitioner.
As in Gray, the confession here is directly accusatory. It's directly accusatory of someone.
Yep.
And
I mean, that could be any of us. So you have to make the connection. How do you get from someone to petitioner?
Correct.
In the testimony.
Correct. And so this is, as in Gray, a situation.
Well, remember, I was in dissent in Gray.
I do remember that, but I will rely on the Court's reasoning in Gray and explain to you why, if you think that Gray is still the law, that Gray applies here. In Gray, this Court acknowledged that there was an additional step that would have to be taken, an inference that the individual whose name was redacted was, in fact, the defendant. And in that case, the Court had no trouble in saying that because there was only one defendant who could plausibly have been the individual who was redacted, that inference could be drawn. And indeed, the Court went further and said that whenever you have a redaction that is apparent on its face, such a confession would categorically be excluded, even if there might be circumstances in which that inference would be less obvious. Our argument is that exactly the same reasoning applies here. And of course, there is a factual difference, which is that the redaction was not apparent on its face. Our test recognizes that, our submission is that the redaction here was pretty obvious by virtue of the way in which this confession came in. The confession in this case came in through the interviewing agent who testified. And over the course of many pages, and this is reproduced in our brief at pages 9 to 11, in the Joint Appendix from 74 to 77, the interviewing agent said that the confessing defendant, Stillwell, referred to another person. I think any juror with those repeated references to another person would wonder, first, why the interviewing agent didn't ask who the other person was, and second, why there were all of these artificial references to another person.
Well,